the process of the sale of real property is a three-part process. There's the contract of sale, which is the agreement between the parties to sell or purchase the property. And that's where you see the mortgage contingency, the marketable title contingency, the inspection contingency that we talked about in the class about the contract of sale. This video will talk about the closing, the meeting where the deed is actually exchanged. So we're going to talk about the kinds of deeds and what kinds of promises those deeds contain from the seller to the buyer, and then what is the process of the closing itself. The important thing to know about the closing, to start with, is that the contract of sale merges into the deed at the closing. What that means is that any promises that the seller made in the contract of sale that are not repeated in the deed are not valid anymore. So the contract of sale is the relationship between the buyer and the seller from the moment they sign the agreement to purchase until the closing when the deed is exchanged. At the closing, whatever their deal is concretized in the deed. And then after the deed has been transferred in exchange for payment of some kind, then we get into recording, which will be the subject of the next video. So let's look at the kinds of deeds. There are three basic kinds of deeds, and first thing we're going to do is we're going to walk through those deeds. There's a general warranty deed. This is the deed by which most people, most of the time, purchase property. And it warrants that the seller will hold the buyer harmless for all defects in title that might arise before and after the grantor took title. So a general warranty deed is a blanket warranty. I am guaranteeing this title to you, buyer. Then there's a narrower deed called a special warranty deed. And again, we're going to look at each one of these deeds. A special warranty deed warrants only against the grantor's own acts. So it says, I will warrant against all defects in title arising from my holding of this property. But it makes no representations about what might have happened before the grantor took the property. And then there's a quitclaim deed, which contains no warranties of any kind, but merely says, whatever title I have, if any, I pass to you, buyer. Let's start by looking at the language of a general warranty deed. This is a sample New York general warranty deed. And you can see that among the things it includes are the date, when is this deed being executed, the grantor, who is transferring the property, and what their address is so they can be precisely identified, and the grantee, the purchaser or receiver of the property, who they are and what their address is. For the consideration of X amount of money, now you don't have to put in the whole purchase price here. You can put in some nominal sum of money and other good and valuable consideration, and that often happens. The grantor hereby bargain, deed, and convey the following described real property to the grantee forever, free and clear, with warranty covenants. And here's the address of the property, and then its legal description. And then come the actual promises of the general warranty deed. And there are 6 key promises that the grantor makes to the grantee. So let's look at them in a list because it's a little bit easier to see. So the covenant of cession, that the grantor is lawfully seized of the property, that the grantor actually owns the property they're conveying. The right to convey, that not only does the grantor own the property, but they have the right to convey it. Covenant against encumbrances, that there are no encumbrances other than the ones listed in the deed itself. A covenant of general warranty, a sort of blanket warranty of the title. A covenant of quiet enjoyment, that the grantor will protect the grantee's quiet enjoyment of the property. And the covenant of further assurances, that the grantor will take any steps necessary after the closing, where the deed is transferred, to make sure that the grantee's title is valid. So let's look at how New York interprets each one of these and how New York has codified each one of these It'll be fairly similar in most states. Obviously, you want to check in whatever state you're dealing in, but for illustrative purposes, let's look at New York. Okay, so RPL Section 253 explains what the covenants in a general warranty deed mean. Cession, first of all. A covenant that the grantor is seized of said premises in fee simple and has a good right to convey the same. Notice, what this law says is that this has to be construed as at the time of the closing, at the time of the execution and delivery of the conveyance, the grantor has to be seized of the property. Remember the adverse possession situation, we talked about invalid deeds, right? If a grantor doesn't have cession, the deed is invalid. So when we had RZ, the bad actor, coming in and selling fraudulent deeds, right, they were violating the covenant of cession. They didn't have cession at the time they were conveying. We also talked about the developer who promised to deliver title in the contract of sale but didn't yet have it. What this tells us is so long as the developer has title at the time of closing, so they've gone around and purchased up all the property, by the time the closing occurs, the transaction is valid and the covenant of cession is not violated. Freedom from encumbrances. Right? A covenant that the said premises are free from encumbrances means that there are no other claims on the property. And you can see there's a laundry list here in the statute. But the important thing to remember is that there are no other claims on the property other than what has already been disclosed. So having homeowner association fees, taxes due, easements, etc., do not violate the freedom from encumbrances so long as they are listed as encumbrances in the deed, so that the purchaser is very clear that the freedom from encumbrances warrant is other than the ones I've told you about. There are no encumbrances. This was the same issue that we dealt with in the contract of sale in the Lohmeyer case about what is marketable title. When encumbrances are disclosed, they are not a burden of title that would violate the general warranty deed. Covenant of quiet enjoyment. Right? This is obviously quite sweeping, and it is a promise from the grantor to the grantee that they will have the peaceful use and enjoyment of their property without any disturbances from both the grantor or any person claiming through the grantor. So it's not a promise that your next door neighbors aren't going to be loud. And it's not a promise that some adverse possessor is not going to enter the property after you've bought it. It promises that nobody that has a claim that arises through the grantor will bother you. So if the grantor allowed there to be an adverse possessor on the property and then sold it to you despite the presence of the adverse possessor, that might violate the covenant of quiet enjoyment. But the fact that somebody enters the property after this transaction would not violate the covenant of quiet enjoyment. Covenant of further assurances commits the grantor and his heirs or successors to do any reasonable actions necessary to vest and confirm title in the grantee. So if things need to be signed, or if they need to verify dates of the transaction, or the grantor needs to go back and produce their mortgage satisfaction, or something, whatever that might need to happen on the grantor's part to make sure that the title is clear in the grantee, the grantor is promising to do that. And then the biggest claim here is the general warranty of title. And this is a promise that the grantor will stand with the grantee against any person lawfully claiming title to the property. And it's a promise to defend the grantee's title. That seems pretty sweeping, right? So we're going to talk about how that really works in practice in a bit. So there are two basic types of covenants in this general warranty deed. There are what are called present covenants and future covenants. Present covenants are in effect at the moment that the deed is transferred, and they can be violated, if at all, only at that moment of closing where the deed is transferred. At that moment, right, the grantor either has cession or not. The grantor either has a right to convey or not. The title either has encumbrances that were not listed or it doesn't. Those are present covenants. They will either be violated or not at the time of closing. Future covenants, on the other hand, are promises that the grantor will do something in the future. They can only be breached if the grantee is disturbed in their possession of the property in the future. So if we break it down, the key clauses in the general warranty deed. The covenant of cession is a present covenant. The right to convey is a present covenant. The covenant against encumbrances, again, a present covenant. The covenant of general warranty, the covenant of quiet enjoyment, and the covenant of future assurances, on the other hand, are all future covenants. They will be breached, if at all, sometime in the future when somebody interferes with the grantee's possession of the property. Now, today, buyers are far more likely to look to title insurance for protection than to the person who sold them the property. Why do you think that is? I mean, there are a couple of obvious reasons, right? First of all, rando person selling property may or may not have any assets to live up to that claim. You may or may not know where they are to pursue them and say, hey, you promised in your general warranty to defend me, right? And now I've got a problem. And they may not have any assets. The process of title insurance arose to fill that gap. So this is a classic excerpt of a title insurance policy, and I put arrows next to some of the pieces I particularly want to highlight. The title insurance company is a company, and it's pretty easy to find the title insurance company. Their name and address is printed at the top of the title insurance form. If they move, the Secretary of State will know where and how to find them. So the title insurance policy covers against the concerns that the general warranty deed concerns. Now you can see that what does the title insurance protect against? It protects against somebody other than the grantor or the person identified as the grantor in the deed actually having title. It protects against any defect in the title that is transferred from the grantor to the grantee, including that the grantor is Z, our bad actor, who forged the deed. It protects against the actual owner being incompetent to transfer the deed, right? If you think back to the adverse possession and the exception for insanity or minority, right? Somebody who is incompetent by law to transfer property. This is captured in the title insurance situation. Failure of cession, right? A failure of any person or entity to have authorized a transfer or conveyance. This would be a violation of the right to convey. The document not being properly created, executed, witnessed, acknowledged, notarized, or delivered, right? If there's a flaw in the transaction itself. When a document is not properly filed or recorded or indexed, we saw that today. We'll talk about that a little later on. Any encroachment, encumbrance, violation, adverse circumstance, right? When there's adverse possession. All of these protections, which are what the general warranty deed purports to protect, are also captured in title insurance. The buyer is going to look to the title insurance and the title insurer to protect them in this context. Okay, so let's do a hypo. This is our first hypo for the day. A sells Blackacre to B, but in a deed that doesn't convey the entire property, it retains 2/3 of the mineral rights. A sells Blackacre saying, I hereby convey to you all of Blackacre except that I retain 2/3 of the mineral rights. Right, so what B has then is ownership of Blackacre and 1/3 of the mineral rights. So they own all of the surface and 1/3 of the mineral rights underground. B then sells to C by a general warranty deed with no exception. So B is saying to C, I sell to you everything, all of the rights associated with Blackacre. 20 years later, and that's just a random number that I picked, C wants to sell Blackacre's mineral rights. And D says, hey, I'll buy them for $30,000. But in doing investigation, because D does due diligence, D discovers this deed from A to B and realizes that because A retained 2/3 of the mineral rights, B couldn't convey those rights to C, and therefore C only owns 1/3 of the mineral rights. So D says, well, I'm only going to pay you 1/3 of the money because I can only buy 1/3 of the rights. C in this situation is obviously upset and sues B for violations of the general warranty deed. C did not get title insurance. By the way, you should always get title insurance, and you should always, if you have a client, advise your client to get title insurance. The title company will do all this research for you. You don't have to go try to figure out where B is. You can deal with the title company. So the question is, did B violate any of the warranties in the deed when B transferred this property by general warranty deed to C? And then what happens with the statute of limitations? Now, I just want to point out that had C been a diligent buyer and done a title search or purchased title insurance and had a title company do the title search for C, C would have discovered the situation. So C is in a quandary of their own making here. And you can see D, who was a diligent purchaser, did the research and discovered the problem. Reminder, these are the covenants in the general warranty deed. So B claimed to be seized of the entire property. That covenant was violated because B wasn't actually seized of the entire property because A had retained 2/3 of the mineral rights. B also claimed to have the right to convey the entire property. That was violated because B did not, in fact, have the right to convey the mineral interests that A had retained. What about the covenant against encumbrances? That was also violated, right? There's an encumbrance on this property in the sense that there's an ownership claim by somebody else. Problem that C is going to run into here with trying to invoke any of those present covenants is, remember, they are violated, if at all, at the time the conveyance occurs. So these three covenants were violated when C got the deed from B 20 years ago. And the statute of limitations in this jurisdiction is 3 years. So even though these three covenants were violated, C can no longer sue under them. What about quiet enjoyment or covenant of general warranty? Have those covenants been violated by the fact that A holds the mineral rights to 2/3 of the underground minerals? And in a case that I didn't ask you to read called Brown v. Lober, a court laid out the explanation for this. And it's the explanation that probably is true in most places. But remember, this law is very jurisdiction by jurisdiction. And the court there said the mere existence of a paramount title, the mere fact that A has better claim to the 2/3 of the mineral rights than does C under the deed they got from B, does not in and of itself breach the covenant of quiet enjoyment. Until somebody exercises that right and goes to excavate and mine those mineral rights, C has no claim for a breach of quiet enjoyment. The court says, yes, there's superior title in another, but until the person who can't sell the mineral rights feels its pressure upon him, meaning somebody else takes action to assert their ownership, there is no breach. So this holder is stuck. The present covenants were breached, but the statute of limitations has run on them. The future covenants aren't breached until and unless somebody else makes a claim. So C is sort of in stasis. They can't sell the mineral rights to somebody else, right? They can't profit from them like they wanted to by selling them to D, but they also can't make a claim under the general warranty deed because there hasn't yet been an action to interfere with their holding. And then we get to the question of, could there be a claim of the mineral rights by adverse possession? And courts have said that possessing the surface does not amount to adverse possession of the mineral rights. So C is really truly stuck here. Again, this is why you want to have title insurance, or at a minimum, do your own due diligence, and because this would easily have been discovered had C done a title search. And just to be clear, a future covenant is only breached when the grantee is actually evicted by somebody holding superior title. So the court here said there's no eviction, meaning there's no trigger of the covenant of quiet enjoyment or of general warranty until someone else claims the minerals. So let's look at the special warranty deed form and see how it's different. Okay, the stuff at the beginning is the same. We don't need to go through it. The stuff in red is the part that's different. Here, the grantor warrants and agrees to defend forever the rights and claims to the above described property against lawful claims of all persons claiming by, through, or under the grantor, but not otherwise. So this special warranty deed brackets what might have happened before the grantor took the property. And this is how New York interprets it. Special warranty deed is a promise from the grantor that they haven't done anything that would encumber the premises in a way not disclosed in the deed. So that they have not tolerated an adverse possessor, or they have not granted an easement that is not disclosed. But they're making no representation as to whether a prior owner might have granted an easement that isn't disclosed, or that a prior owner might have tolerated an adverse possessor in a way that would affect the purchaser's holding. So it's a little hard to see, but I wanted to show you this is an actual special warranty deed. And the part down here that I sort of highlighted out is the key, the operational language. And you can see, right, it starts with a description. This is a property in Long Island City. You can see there's a description of the property, a legal description of the property. And if there were any easements, they would be listed here, or any, if there was a homeowners association, etc. And then down here is where you see what exactly is the grantor promising. And the grantor here is promising that the grantor did not do anything or suffer anything to encumber the property, except as was listed, if anything was listed in the description of the property. That's the key language that tells you that this is a special warranty deed. So let's do a hypothetical. For 15 years, there's been a fence between A's property and that of her next door neighbor B. A sells her home and land to C by a special warranty deed, which states in the key part, the grantor conveys that she has not done or suffered anything whereby said premises have been encumbered in any way whatsoever except as aforesaid. That's the language we just saw. Now, a few years later, B claims a part of the land described in C's deed under adverse possession. And it turns out that the fence between the two properties was not on the boundary, but was actually built 10 feet into A's land. So first of all, if you think about this, which element of adverse possession will be key? We know that there's been a fence for 15 years, so the statutory period has been satisfied. A fence is one of the ways you can claim exclusive ownership. The question, of course, will be, the key element will be whether or not there was enough notice, right? In New York, the legislature amended adverse possession to say that encroachment by fences in and of itself does not amount to adverse possession. So it's going to be a question, right? Is this open and notorious enough such that B should have known and C should have known that there was an encroachment on the property and that the property was in jeopardy? Let's say that it was, just for purposes of getting to the second question, which is, can C bring a claim against A for breach of special warranty? We don't know how long A owned the property, but that doesn't really, even if the fence was built before A owned the property, it's clear that part of the adverse possession occurred during A's tenure. And A promised that they have not suffered anything to happen that would encumber the premises. And by tolerating an adverse possessor and not evicting that adverse possessor, right, A has violated this special warranty. Then we get to the quitclaim deed. A quitclaim deed makes no representations about ownership of anything. It just says, if I own anything, I'm going to pass it on to you. So by this deed, I pass whatever I have, if anything, on to you, grantee. If you think back to a case about Jesse Leeds' will, remember Jesse Leeds' living siblings who were not part of the litigation. The litigation is between Evelyn White and the estranged nieces and nephews who are claiming that they have a remainder in the property because they're claiming that that grant to Evelyn White is just a life estate. Now, there were living siblings of Jesse Lead who could also have been part of that litigation claiming the remainder, but they quit-claimed their interest to Evelyn White. They said, we don't know if we own anything here. We don't know if this was a grant to you of the property with an unlawful restraint on alienation, or if this was a life estate and a remainder. And quite frankly, we don't care. Whatever we might theoretically have, we give to you, Evelyn White, because, in this case, because they clearly thought that that was what Jesse Lead wanted. So a quitclaim deed is often used to clean up title. If there are clouds on a title, if there are people who might potentially have a claim, right, you can get them to issue a quitclaim deed, and that clears up all of the problems of who might have what claim and can unite the fee in one person. You can pay somebody for a quitclaim deed. It could be a nominal sum. Right? It could also be, right, you might have to buy somebody off and really pay them a lot of money. But lots of times, like Jesse Lead's living siblings, someone will just execute a quitclaim deed because they don't really think they have any ownership and they want to help out by clearing up the title. Okay, so that's the end of this video. The message here is there are 3 kinds of deeds. Make sure you know the differences between a general warranty deed, a special warranty deed, and a quitclaim deed, because they have fairly significant ramifications for the purchaser. And if you are the purchaser or you are representing a purchaser, you want to make sure that you know exactly what it is that you're buying. Now, as I said, most of the time, most people who purchase property are getting a general warranty deed. That would be the default, but you want to make sure, don't trust that the bank is handling it. Don't trust anybody else. Make sure of it yourself, because you are the lawyer. Next up, what do you do once you have the deed? Let's talk about the Recording Act.